recording this, sorry, is our conception of the executive as a completely unitary pyramidal scheme with the president at top, and so everybody reports to the president has the final say? Or is it more scattered, diffuse, less hierarchical? And this has been a politically salient and divisive argument now since the Reagan administration, where in general, political conservatives are more in favor of a unitary conception of the executive branch, political liberals less so, though it depends a lot on who the president is. Suddenly conservatives are less enthusiastic about a unitary executive when there's a Democratic president, and Democrats become a lot more so. So where people stand depends on where they sit, not surprisingly. So all of this then brings us to Selah, which is this question of how important is it that the president be able to run the show, and how much of an interference with the president's ability to run the show is this particular structure, the combination of a single person and for-cause removal restriction. Okay, that's the appropriations, I think, is lurking in the background, and it provides some color. And there are scholars who think that's really the critical thing, and there are litigants who have challenged have made a great deal out of the appropriations question. In the Supreme Court, that's largely invisible. It's mentioned, but it's largely invisible. In Seila Law, the court treats this as completely a question of the president's power to remove. And it strikes down this arrangement, 5-4, with the 5 conservatives in the majority and an opinion by the Chief Justice. As always, it's when the Chief Justice, who assigns opinions, keeps one for himself. It's a sign that it's a big deal case. And Justice Kagan writing a dissent for the 4 liberals, where in essence, though the Chief Justice does not use the phrase unitary executive, he is endorsing a very pervasive understanding of that view of the executive as a unitary entity with one person, the president, in charge. And so they strike down this arrangement. The Seila Law had said if you strike down the for-cause provision, then the whole agency has to go. Everything collapses with that. You've said this is an unconstitutional arrangement, quote, the agency is unconstitutional, that's that. And the majority did not do that, very pointedly did not do that. So this is a question of severance. Anytime you have a statute with multiple provisions and a court decides that one of those provisions is unconstitutional, it has to decide, does that mean everything goes, or do we just excise the unconstitutional provision and leave the rest and go about our merry way? In this case, they took the latter approach. So the president cannot be prevented from firing the head of the CFPB. And we will see if there is a statutory response. The court invites one. But the CFPB remains in business. 7 justices thought this was the right approach. Justice Thomas, joined by Justice Gorsuch, argued that no, the whole statute should go. So where does this leave us? A couple general points, and I should say, if anyone has a question, just ask it through chat, please, and we will certainly get to it. But I want to just say a couple of things about where this leaves us. First of all, like I said, the immediate effect of this decision is extremely modest. After all, the CFPB is being run by a Trump appointee who believes that the provision was unconstitutional. As I should have mentioned before, the position of the Department of Justice was that this is unconstitutional. So the Solicitor General argued against the constitutionality of the statute. The court appointed Paul Clement, former Solicitor General, generally acknowledged to be, if not the best, one of the top 5 Supreme Court advocates now alive, to argue as an amicus for the constitutionality of this arrangement. So the CFPB will just do what it's been doing. It's unaffected as a practical matter like this, and there are not very many other agencies like this. The majority and the dissent argue about, they agree on how many there are, they argue about whether they're significant or not. The reality is there is not another agency just like this. The most important other agency that's set up like this is the Social Security Administration, single head, for-cause protection. But it's not a regulatory agency in the same way. Its decisions don't have the same kind of impact. So you know, even if all 3 of these agencies now have to be restructured, that's not such a big deal. What is a big deal is the consequences this may have for these battles going forward. Pointedly, the court did not overrule Humphrey's executor. But Humphrey's executor has been in the crosshairs of unitary executive enthusiasts for many decades now, and it's slowly being chipped away at. Justice Thomas would strike it down completely. Justice Thomas, joined by Gorsuch, points out that it's slowly being chipped away at. It feels more and more vulnerable. So it didn't happen here. But this is absolutely another step towards reconceiving the whole idea of the independent agency and whether, in fact, those are permissible. Now, as long as Chief Justice Roberts is on the court, they're not going to wholesale get rid of independent agencies. But the characteristics of agencies that permit the independent structure, the for-cause protection, will be steadily, permissible characteristics will be steadily narrowed. The list of what kind of agencies might be set up this way will get narrower and narrower. I will say that limited to this particular decision, it's not at all clear to me the court's decision was wrong. I'm not a unitary executive guy. I think Humphrey's executor was rightly decided. I'd be sorry to see it go. And I think the courts are kind of making this up. But if you take the doctrine seriously, there is a meaningful way in which the president's influence over this agency is hugely restricted. And the best way to think about it, let's say Elizabeth Warren, rather than Joe Biden was the Democratic nominee. Let's say Elizabeth Warren was elected president, and in January 2021, she becomes president of the United States, and she inherits Trump's CFPB head, this Kathy Canninger woman, who I guarantee you has a very different worldview than Elizabeth Warren. And unlike the other executive agencies, where the president generally appoints the chair, where there's a majority, though there are bipartisanship requirements, the majority will be from one party, which at least sooner rather than later, and maybe immediately, will be the president's party. There's nothing Elizabeth Warren can do about Kathy Canninger running the CFPB. That is a much more significant interference with the president's ability to do its job than, say, Humphrey's executor. So again, the outcome, I think, is not hugely consequential and may actually be right, though many people whose work I admire enormously think it's definitely wrong. But the foundation laid in this opinion, which does a couple of things, stresses that the basic presumptive starting point is the president has the power to remove untrammeled, period. And the only question is what, quote, exceptions, a word that has never been used that I recall in this setting, what kind of exceptions to that basic setup are permissible? Second, the court grounds this presidential authority in the vesting clause. So Article 2, which is about the president, famously is sort of short on actual enumerated specified powers, right? Article 1 about the Congress has a long list of things Congress can do. Article 2 says not that much about what the president can do. And so one is always sort of hunting around to find something. the removal stuff has typically been rested more emphatically on the take care clause than anything else. But there's been a long debate about whether, when the Constitution says all executive powers are vested in a president of the United States, that actually hands the president some powers, whatever the executive powers are, or whether it describes the kind of powers that are thereafter enumerated in Article 2, and the critical language is a president. We're telling you who the figure is, and now later we will tell you who the officer is, and later we'll tell you what powers he has. In the Steele seizure case, a majority of the court explicitly held that the vesting power does not grant authority, but the argument never goes away. And Chief Justice Roberts says in so many words in this opinion, the power to remove comes from the vesting clause, right? So it's a very explicit statement of the vesting clause grants presidential authority, and it got 5 votes. And it's a sort of hidden aspect of this opinion that could prove very consequential, not just with regard to removal, but across the board. Third, he points out that the agencies are wielding the president's power, right? In other words, they are standing in the shoes of the president, and that's why the president has to have the removal power. And again, that's the Unitarian stance. But the competing view, and frankly, it's been the more mainstream view, is that when Congress creates an agency, Congress gives power to the agency. And it has set up this entity, which sure is subject to some presidential supervision, and sure the president will appoint the officer. But the agency is exercising its own power, the power Congress has given it. And the president doesn't have the authority to tell the agency what to do. The president can't do it instead of the agency. That would violate the statute. The statute says the agency has this authority. So for the Chief Justice to sort of blithely say, oh, well, they're just wielding the president's power, is a second sort of remarkable pro-president bit of rhetoric, and not just rhetoric, but doctrine in this opinion. So you roll those together. And the question is, what happens next? Because how does law change? It's frequently law changes when courts do something where the bottom line, the effect is not all that striking or consequential. But the language in the opinion represents a fundamental shift. And then down the road, a year or two, 5 years later, the language is used to take the step that is more consequential. Right? You see this in the common law all the time. I'm looking at Arthur Jacobson. It's an aspect of dynamic jurisprudence in the common law. And the same is true in constitutional cases, despite the existence of a text. And so it's too early to say just where this is going, but it could be enormously important. One last coda, and then I really will shut up, on the severability question. There's another case pending before the Supreme Court right now with a huge severability issue, and that's the latest litigation about the Affordable Care Act, Obamacare. It will be argued in the fall, but the Solicitor General just filed his brief, the last brief filed by the outgoing Solicitor General, Noel Francisco. And it takes a very strong anti-severability stance, that because the individual mandate is unconstitutional, according to the Fifth Circuit anyways, and has been essentially abandoned by Congress, the requirement, well, I don't want to get into this case, the sanction has been abandoned by Congress, thus, according to the court, making the individual mandate no longer enforceable, thus making it not part of the taxing power as the Supreme Court had held. And thus, once that's gone, the whole law has to go. So the court is going to face this huge severability issue in the fall. And if it takes the approach set out by the Chief Justice in this opinion, and endorsed again by 6 others, the federal government will lose in a big way on that case. So the sort of pro-regulatory readers of this opinion take some solace, I think appropriately, in the severability discussion, that language, certainly the language from this opinion, will be trotted out in the ACA debate and litigation, and should suggest that the court, if it is principled as we hope it is not going to strike down the entire ACA. All right, I will stop there, and I'm delighted to answer any questions if people have them. So there's an interesting question here from Professor Pearlstein about the role of inspectors general. So 30 seconds of background. Many of you may be aware of this because it's been in the paper a lot. Most agencies, and every important agency, has an officer called the Inspector General, which is a really interesting, understudied, under-theorized, and usually below the radar position. More recently, it's been totally above the radar. And the Inspector General's job is to make sure that the agency doesn't violate the law. Usually not so much the kind of thing we're thinking about, oh, you know, regulation, arbitrary and capricious, but rather with regard to, you know, are they keeping track of receipts properly? Are they, you know, is everything above board? It's at its narrowest, it's a kind of accounting position, but it goes far, far beyond accounting in important cases. And it's where whistleblowers go if they have a complaint. And Donald Trump has been firing a lot of inspectors general recently. And then the question is, to the extent that inspectors general are protected by forcause provisions, right? What is the meaning of this case for them, right? They're not agency heads. So one argument would be they are inferior officers. And one of the things that the Chief Justice expressly says is an inferior officer is within, that's, you know, our two exceptions to our basic premise are A, the FTC, the non or quasi executive multi-member expert agency, and B, inferior officers. And so if you know, I think what I would, if I was arguing it, I'd argue they're inferior officers. Now the problem is, of course, they only have a dotted line to report to anybody, right? And that suggests, because they can't do their job if they're constantly reporting to people. If this was Morrison against Olson, it's an easy case, right? They're to the, you know, if the independent counsel is an inferior officer, IGs are inferior officers, but Morrison is in deep trouble. Was already in deep trouble, is in deep trouble after this. So I don't have a definitive bottom line on that one, Deborah, but that's my sense. So, I agree that it is a potential and concerning ripple effect of this decision.
Thanks, that's helpful. I'm sorry to jump in. I think your point about inferior officers and that distinction is extremely well taken. You know, given that the IGs have a more general mandate or jurisdiction, arguably, than the, as you point out, already in trouble independent counsel, I worry some about whether they'll try to say this is not an inferior officer, but they should say it's an inferior officer. I think what made me, my initial reaction to that argument was, no, this is a really narrowly written opinion, and I quite agree with you. It's not entirely clear, it's wrongly decided even in the scope of existing removal cases. However, the point you made a few minutes ago in the course of your comments, both about the grounding of the removal authority in the vesting clause, which is new, and maybe even more concerning, the embrace of the view that these are actors carrying out the president's authority, or these are actors exercising the president's authority and not exercising Congress's authority, which I think is wrong. But you know, there it is. Those two things are actually those are much more concerning to me than the And I hadn't thought about that enough before. Thanks a lot.
Yeah. Arthur Jacobson asks, why hasn't Congress ever resolved these issues? I'd answer that on two levels, maybe three. One is, look, Congress is Congress. Congress doesn't like making hard decisions. So, you know, you're going to be disappointed if you look to Congress to make hard decisions. Secondly, you know, to some extent, Congress has, that is to say, Congress created the CFPB. Congress said, here is a structure we want and we think makes sense and is justified on a policy ground, and we think it's constitutional. And along comes the Supreme Court and says, no, it's not constitutional. That itself is not an issue Congress can decide. Right, that's the court's job. The third thing is, it's a little bit like all the fight about subpoena authority, right? Which now it looks like is finally going to get a decision from the United States Supreme Court. Though still they may, who knows how they might punt it, and, you know, we'll see. But, you know, for centuries, it's not ever been completely clear what Congress's subpoena power is, because it's always sort of worked out politically on the side. A compromise is reached because neither side wants to push it all the way, right? Nobody, I said probably 10 times just now that the statute provides that the head of the CFPB can be fired only for cause. Nobody knows what that is, okay? There's no case law about what cause is, or no case law about what inefficiency, malfeasance, and neglect of duty, which is other typical statutory language, is. Because the president doesn't do it. So the reason Humphrey's executor is such a big deal is because that's a case where the president actually fired an FTC commissioner, right? And then they had to figure out whether that was okay or not. Those cases don't happen. The president doesn't test his authority to fire. And so Congress can get away with keep going back to the same vague language, which is never really tested and no one knows the answer to, and we all just kind of muddle through. One of the reasons we muddle through is that that independent agencies are less independent than you would guess as a practical matter. That even without the removal authority, the president has important techniques for influencing and overseeing independent agencies. But I think, so that would be my answer to Arthur. And I think that's a little bit I got a private question about what is the real, you know, what's the significance of a for-cause restriction? The question asked, you know, would it be unfair to allow the president to fire without cause? Well, it may or may not be unfair. I will say, so historically, of course, almost all employment in the government and otherwise was at the will of the employer, right? That you could make a contractual arrangement to to give yourself some additional protection. But the basic model is at-will employment. That's what employment historically has been in our legal system. More recently, there have been important statutory restrictions, most obviously the anti-discrimination laws. And before the anti-discrimination laws, a big movement against that was the labor movement. But it still remains the case that lots of employment is at will. So it's not quite as weird as all that, just as a general point. But secondly, the argument would be, yeah, it may be unfair. You know, if we think it's unfair to the head of the EPA that the president can fire him for any reason or no reason at all, the response is, yeah, but you know what? I care more about the state of the country and the president, the duly elected president's ability to run the show and make sure that the president, well, to take care that the laws are faithfully executed, than I do about unfairness to the head of the EPA. So the basic model of there being at-will positions in the federal government don't think it's not seriously contested as inherently problematic. The only question is does it always have to be that way, or when does it have to be that way? Not is it acceptable? Monroe, I don't know enough about the EU to say something intelligent. I think that, about the EU aspect, when you ask how bankrupt is the idea of independence, I think I would answer this in terms of, there's a funny thing going on in this opinion which runs through and through all these cases, which is often described in terms of formalism and functionalism. Does it matter? Is it a purely legal question? Is the key issue the legal arrangement here, or is the key issue how things operate in practice? So removal is one of those things that if you're a formalist, you say, well, if the president can fire this person, then the president controls that person. If the president can't fire this person, then the president doesn't control this person. The functionalist is to say, well, maybe, but I can think of lots of settings where a president would like to fire someone and can't because of political ramifications. Janet Reno was Attorney General for 8 years, and for about 6 of those, Bill Clinton really wished she would leave, but there was no way he could fire her. J. Edgar Hoover served at the president's pleasure, and no one could fire him. And on the other hand, if I've appointed the chair of the independent agency, if I've done a good job appointing him, gotten someone who's on the same page as me, understands what I want, and we see eye to eye, I don't need the power to remove that chair to be quite confident in what I'm going to get. Turning back to this opinion for 1 second, there is this fight. I got to say, I think Justice Kagan's dissent is fantastic. It makes a critical move, which I at least am unconvinced by. And she says, look, in the real world, it's easier to get a single person to do what you want than to get a group to do what you want. So the president, as a practical matter, probably has more influence over the head of the CFPB, because it has a single head, than over, say, the FCC, because there are 5 of them. And it's hard to, just think about your ordinary life. It's always harder to get a group to cooperate rather than just leaning on or job owning a single individual. And it's a kind of homespun, common sense, seat of the pants wisdom that seems sort of right. I just think it's wrong in this situation, right? Because you have to imagine the president who's upset with an individual that he didn't appoint, right? Left over from a prior administration. And then the fact that there's only one of them is not gonna, the president just doesn't have enough sticks. But that's a purely kind of functional argument suggesting that the idea of independence may also be bankrupt in that way. Samantha Chase asks about non-delegation. It's actually a great question because non-delegation is always in the background of these cases. If the agency was exercising very little authority, not making important decisions, or if the agency was exercising what we might call purely executive authority, like say, doing investigations, then the cases become a lot easier. The separation of powers concern writ large is a concern that Congress has given the agency what ought to be legislative authority, and now how are we going to rein it in? And that's a way of bringing in the appropriations issue. That is, what it would be coherent to say here that the problem is the president's ability to oversee is reduced by the removal protection. Congress's ability to oversee is reduced by the appropriations measure. And so that leaves this agency with a huge amount of governmental authority. We're worried about because it's a broad delegation. I don't care if it's a constitutional delegation or not, but it's a broad delegation. And now you have created the so-called headless fourth branch of government. And we're more happy if there's at least some entity there to check the agency. Now, maybe that's the courts, but if it's a very broad delegation, you haven't given the courts that much to work with. There's not much for the courts to enforce. Question about, how come we have Thomas and Gorsuch on one side and Kavanaugh and Alito joining the chief, but not them. I know this case isn't a non-delegation case, or is at least slightly encouraging that other right-wing justices don't seem eager to move as far. Look, Thomas, I guess I want to separate Thomas from everybody else, okay? Gorsuch, it's a little too early to say, when is he a fire thrower and when is he not? Thomas, is just far and away the most extreme person on this court and most willing to just toss it all out, to hell with it. We took a wrong turn 180 years ago and the time has come we're going to ignore whatever's gone on. It's a weird sort of, he's not a Burkean conservative, whatever kind of conservative he is. And so it's, not at all a surprise that Thomas took this position. I think one can quibble a little bit with his statutory as opposed to the constitutional consistency, because this statute has a specific severability clause that says if any given provision is found unconstitutional, everything else, it should be severed and everything else stands. That's in the text. And he has to work kind of hard to get around that. I mean, he's got a theory, he's got an argument, but it's really, textualist meets textualist between the chief and him on this. And I think if Thomas is the loser in that. But his constitutional approach, right or wrong, actually tends to be pretty consistent. He will assess what he thinks was the original understanding and enforce that no matter what, at any cost, at the expense of any sort of existing case law. I don't think there's any other, and so the chief is the opposite, right? The chief is an incrementalist. The chief is an institutionalist. The chief cares about what things look like. And doesn't want to upset the apple cart. And so where Alito and Kavanaugh and Gorsuch fall between those two, I think we're still kind of seeing, and I don't think they've been totally consistent themselves, but there's nobody, Gorsuch may prove to be the most Thomas-like member of the court, and this would be one of the data points suggesting it, right? I mean, he does have Thomas's, call it hubris. I mean, Supreme Court justices are all full of themselves, but there's still some, do they ever pause to think they might be wrong, right? And by and large, they're not required to do that, and they lose the skill the longer they sit on the bench. Gorsuch has come in like gangbusters from the beginning, right? Without really, he really is quite sure he's correct. I think we've gone on longer than we were supposed to. And we should probably wrap it up at that point. Thanks for your attention. I hope this was at least a little bit interesting. And we will bring the proceedings to an end. Stay tuned for more of these unboxing the laws from the Cardozo faculty.